call the meeting to order of the Town of Lake Clark Shores Code Enforcement Board hearing, March 24th, 6:32. Emily, would you call the roll, please?
Paul Hughes,
Present.
Timothy Daughtry,
Here.
Benjamin Hartman,
Here.
Ariel Hernandez,
Present.
Trent Swift, Gerard Sanchez, Robert Gonzalez.
Present.
Did you call Ken? Is he? Ken?
Ken resigned.
Oh, he did?
Yeah,
don't
last
see my
year he
name on there.
moved. He moved.
Oh, I didn't-
Yeah, that's why Robert is
That's
there.
okay.
Sorry about that. Okay. We'll stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. The chair would entertain a motion for approving the agenda.
So moved.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Anyone opposed? Motion carries. The consent agenda is the next item, which includes approval of the minutes of the February 24th, 2021 Code Enforcement Board hearing. Any unfinished cases now in compliance, and any new cases now in compliance. Dana, I believe we have a couple of cases that are in compliance.
Yes, on page 3, second case 21-0080, Michael R. Fritz is in compliance.
Michael Fritz?
Yes.
Okay.
And then on that same page, 21-0083,
Mhm.
in Nay Taekwondo, that is also in compliance.
Okay. That it?
Hold on. Why is,
Did not print?
I have the other agenda. Let me get the,
Sorry about that.
they're blank pages.
I don't know what happened.
Yeah, I don't have any either.
And then on page 4, which you guys might not have, is case number 21-0099, Thomas Cheatham. That is also in compliance, and that would be off.
210.
099.
Okay.
I need my Captain Crunch magic decoder to read.
All right, well, we'll wing it.
Emily, you probably could put the agenda on the TV for them, no?
Oh, yes, I can do that.
Okay.
Sometimes I have to, just sometimes.
It's a very good idea.
Is there a motion to accept the consent
So moved.
agendas? Is there a second?
Second. Second.
All those in favor say aye.
Aye.
Is there anyone opposed? Motion carries. We'll remind the board members that if you have recently been by a property that you're particularly familiar with, as it comes in the meeting, it comes up in the meeting, if you'd please disclose that at the time we discuss it.
And maybe it would be a good idea for me just to refresh your memory as to why that's required. This is a quasi judicial hearing, and although it is informal as it relates to legal procedure, it does have certain legal requirements. One is that ex parte communications outside of the hearing are discouraged. You're not prohibited from going and looking at the property, but if you talk to anybody about the case, or if you review the case by looking at the property or going online and looking at county tax records or appraisal records, you're required to disclose that. The reason is that should the alleged perpetrator, the person in violation, be represented by an attorney, the attorney has the ability then to cross-examine you as to what your state of mind is from that review of the case outside of the hearing. And that's the reason it has to be disclosed on the record. If it's not disclosed, then it's considered a violation.
That makes sense. Thank you, Charlie. Okay. The next item is swearing in of witnesses by the town's attorney. Anyone that's going to be speaking relative to a case, please stand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you.
Thank you. The next item is unfinished cases and lien imposition hearing. And I believe that in the next 1, 2, 5 cases, this is Ms. Terhune. We're looking at the lien imposition, I believe. Okay, so we'll discuss all these cases together, and if there's any motions, we'll take them separately regarding Ms. Terhune. Discussion, Dana, anything new whatsoever?
No, and I've placed the code orders. And what was the last thing in the envelope you had?
It was
delivered?
the nuisance letter to let her know or let them know that we would abate the violations if she doesn't or if she doesn't take care of it within 30 days.
I delivered the code hearing notices, and then that was also delivered by one of the ships.
Okay. Well, it would appear the property, and when's the last time you looked at the property, Dana?
Today at 4:03 when I took the photos.
Hold on.
Okay,
It does appear like, if any of you have driven by, it does appear that some of the neighbors are parking at the property. So you might think someone is staying there, but it's just the people across the street.
okay. Well, it would appear that the property is still not in compliance. Discussion among the members?
So I have checked out online to see what the records are, if there's been a foreclosure filing or anything in the public records. And as of right now, there's nothing I can see that's been done. As far as that goes, I don't know if that's something that will be done. I know if we impose the lien, it then goes over to town council.
Correct.
That may be the right play, because I don't think anything's going to happen here. And it may be worthwhile if there's no resident there, and if we impose the lien, it may be worthwhile for the council to take the next step.
Dana, or not, I'm sorry, Emily, what would be the aggregate fines through today?
Right here.
So
Oh, yeah.
you have the sheet.
$7,135.
You're actually getting so efficient here. I'm $7,000 is,
Yeah, that's as of today.
okay.
7135.
So let me ask you a question. Is there any way of getting hold of anybody involved with this property or whatever, or?
I think, Mr. Daugherty, I think the only way that we can get any attention on this is if we move forward with imposing a lien and getting the attention of either the reverse mortgage company, which we had discussed in the last meeting. Other than that, I think that Dana's tried every avenue.
Okay, I'm just wondering if anybody knew anybody at any place.
I mean, it pains me to impose the lien because of her situation, and she's not living in the home, and we understand upon information and belief that she's at a assisted living facility. I think is what we understand is what we've been able to figure out from the public, but I think that this is the only way to get their attention. So I'm going to go ahead and make a motion based on testimony and evidence presented in case 21-0008. I move that this board impose a lien against the respondent's property, which shall be recorded in the public records of Palm Beach County.
Is there a second?
Before we second, if I may just add something to that, I'm in agreement. From the records, if we haven't heard from a family member or anything by this point, I doubt that we will. But if there is a way still to, I think if we do this, the company that has the reverse mortgage is an entity that I am familiar with. They are very reasonable in dealing. A reverse mortgage short sale is something that can be arranged and taken from start to finish in about 60 to 90 days max. But I think this is the step that we need to take. So I'll second that, but I wanted to make that statement
What's
first.
the situation here? I wasn't,
All right, so wait 1 second there. The motion's been moved and seconded, so we'll go to further discussion.
yeah. Yeah, I actually don't have any background. So, and it didn't stand out to me in the review of the minutes. So
Okay, well, the original citation was filed when, Dana?
it looks like in January, according to the spreadsheet, right? Violation date is 1/27. And so we've gotten
Nothing.
It's being unfair. It's
I don't think.
No
there's
communication.
Been no feedback from.
is there any signs of like people visiting or anything? No.
Now, Dana's extensively provided the board with some testimony on the last meeting, and I think even the meeting before that, where she's tried to get a hold of the daughter. She's spoken to neighbors, and please correct me if I'm misstating the testimony, but certainly she's given every effort to try to bring the property into compliance, to get a hold of somebody, to post notices. And it's a sad situation that we have a resident that is aging and is now at an assisted living facility, is not able to do it herself. And I don't know if she has anybody to help her, but we haven't been able to make that communication. And through public records, we've been able to determine that there is a reverse mortgage.
Okay, so Mr. Sanchez has a motion that's been moved and seconded on the floor. Is there any further discussion on 210008? All in favor of the motion signify by saying aye.
Aye.
Is there anyone opposed? Motion carries. All right, next case is 0009.
Would you like, I'm going to go ahead and make a motion on all of these. I don't know if we
We're
want
gonna
to.
have to do them individually.
Correct.
Okay,
Based on testimony and evidence presented in case number 21-009, I move that this board impose a lien against the respondent's property, which shall be recorded in the public records of Palm Beach County.
is there a second?
Second.
Now, this is an opportunity to discuss this if anybody wants to, or you feel like you have enough information already.
From where I'm sitting, I feel like it's the proper move to impose the lien. And if things do get together and they're able to take care of this and they want to go through either reverse mortgage short sale or not, it's an FHA backed loan. They got to sell it for 95% of whatever appraised value is. That can be quick, that can be easy, especially in today's market. If we impose the lien, it's on title, it has to get paid upon closing. We can recoup the funds within 6 months.
All those in favor of the motion signify by saying aye.
Aye.
Anyone opposed? Motion carries.
Thanks.
0010.
Based on the testimony and evidence presented in case number 21-0010, I move that this board impose a lien against the respondent's property, which shall be recorded in the public records of Palm Beach County.
Is there a second?
Second.
Any discussion related to the complaint of mildew on the roof? If not, we'll go ahead and vote. All those in favor signify by saying aye.
Aye.
Anyone opposed? Motion carries. 21-0011.
Based on the testimony and evidence presented in case number 21-0011, I move that this board impose a lien against respondent's property, which shall be recorded in the public records of Palm Beach County.
Is there a second?
Second.
Any discussion related to fence in disrepair that we've seen on the screens? If not, all those in favor of the motion signify by saying aye.
Aye.
Anyone opposed? Motion carries.
Based on the testimony and evidence presented in case number 21-0012, I move that this board impose a lien against respondent's property, which shall be recorded in the public records of Palm Beach County.
Is there a second?
Second.
Is there any further discussion on peeling paint on the residents? If not, all those in favor of the motion signify by saying aye.
Aye.
Anyone opposed? Motion carries. All right. We will now go into new cases on page 2 of 5. 21-0078. This is operating without a business license, Bridge to Mental Health Healing.
And if I could just take a moment and refresh your memory, the imposition of penalties on non-payment of a business tax receipt is governed by Chapter 205, subsection 053 of the Florida statutes. And in subsection 1 of that statute, it says that for business tax receipts that are pre-existing, if it's not renewed, there's a penalty of 10% in the month of October, plus an additional 5% penalty for each subsequent month, up to a total of 25% of the business tax. If they're new and operating and have never had a receipt, it's not calculated by the 10% and the 5%. It's a flat 25% penalty. Then subsection 3 states that once the notice has gone out to the people that they are required to obtain the business tax receipt and they do not, then they are responsible for all of the costs related to the enforcement of the business tax receipt, including court costs, if any, reasonable attorney's fees, administrative costs, as a result of the collection efforts. And you have the ability, as the code enforcement board, to impose a fine or a penalty of up to $250. So your actions tonight are such that you can impose a penalty if you find that they're in violation, and it's up to $250.
Now,
Cannot exceed the $250.
now, is there a difference between a new license and a existing license relative to what you just said?
No.
Okay.
The other penalty, the 25% for a new license that has not been obtained, and the up to 25% with the 10%, 5% for each subsequent month, is automatic, and that's imposed by the town. So if they come in November, they're going to pay a 10% penalty. If they come in December, they're going to pay a 15% penalty.
So I've got one question. Why is Leo Express
So which one?
listed twice?
It is because one is for the doctor, Gracia LeBron, and then the other one is for the nurse. Let me see here. The nurse is, I don't know how you say this name, Leonie Pierre Vernet. So it's not associated necessarily with the business, it's associated with the occupation.
The practitioner?
An individual license, right?
Yeah. But they work for the same company.
So for example, in my office, each of the attorneys has to have a business tax receipt. If one of them doesn't, then there's a case against that particular attorney. If more than one doesn't, then you can have multiple cases.
Gotcha.
How would the board like to discuss some of these general matters? Do you want to take them one by one?
I have a question, Charlie. In these cases here where we're just discussing whether they have or have not applied for a new license or a renewal, do we need to debate and discuss each one individually, or?
You have to go through each one individually. Unfortunately, there's no one here representing any of these parties. So the record should reflect that there's no one here to present the alleged violators' position. And if they were here, they could explain to you that they were no longer in business, or that it was an oversight and that they'll pay it immediately or whatever. But in this case, there's no one here to give you any contrary evidence to the fact that they have not paid the business tax receipt.
Okay,
And
So these can be rather short
gotcha.
as far as the discussion is concerned.
And we have assurances that the proper notice went out, correct?
Yeah.
Yes.
Okay.
All right. Who would like to take on 0078?
There's if you look at your sheet, it's on the page 2,
Number 8.
section 8, which has the suggested language.
Are any of these new businesses?
I do not know.
Yeah, I was gonna say, how would you know?
No, I just know the statute
Uh,
distinguishes between a new business or a new tax receipt and a
Well,
renewal.
interestingly enough, we're past the period of time where whether you're an existing business and did not renew your receipt, or whether you're a new business and did not obtain the receipt, the 25% penalty is going to be imposed because they're at that 25% max, plus whatever penalty you impose on the notice of violation.
So I see the thing on note 8, okay? So we cite the case, we cite the violation, additional penalty amount could be $250, correct?
Up to?
Yes,
Up to,
up to
okay,
and
and then,
including $250.
and the respondent would be required to pay a total. Is that the total amount at the end of this?
The total
spreadsheet?
would be that.
Yes,
plus-
yes, it is.
Okay,
That's correct.
and then, and if the respondent is not in compliance by what it would be reported, that's what we got to decide on.
Yeah.
Okay,
Since these cases essentially elicit the same fact pattern, would the board like to have an open discussion on compliance in terms of 60 or 90 days, 30, 60, 90? So that we can
Sure.
treat all of them equally?
That'd make it a little
Think so.
easier, I think, when we do each motion. So I guess the question would be, how long do we want to give these companies the opportunity to come into compliance before any fines are imposed?
wouldn't you want to know that their licenses all expire September 30th, correct?
Correct.
So she's been trying to get them for quite some time, just so you know.
Yeah.
Okay.
I know she sent out multiple letters.
It's now
We
been
can impose it.
almost 6 months.
We can
Yeah.
impose it as of today?
And
No, typically you would, if they don't come into compliance by the next meeting is what you typically do.
Right, that's what we
But-
typically do, but that's why I'm asking you specifically if that's necessary
No, it's not necessary.
after this length of time.
Correct.
Well, I guess just as a suggestion, maybe we do 20 days. If I'm getting served with a complaint, I've got 20 days to answer a complaint, and I think that that's something that's fair. It's important, doing business in the town. We appreciate our businesses, but we also want to make sure we have a good relationship and that we have that we hold up our end of the bargain and they hold up their end of the bargain. And so, are we okay with 20 days?
I think we should go to the next meeting. That's my personal.
I may have missed it, but how many notices would these parties have gotten, Emily?
I don't take care of these, but I think it would be 2 notices.
I believe it is 2 notices.
So they've already gotten 2 notices
And the hearing date.
and the
Yes.
hearing date.
Yeah.
So that's kind of 3 notices.
And then
Yeah.
I will tell you, Rock Point Academy has been here for quite some time, and I'm almost positive they do this all the time.
Well.
Just so
Well,
you know.
Are you,
we don't know for sure.
Well, they've been here for a while, and they've been on here the list
Before.
before, yes.
Okay.
are you familiar with any of the other businesses that have been on the list before?
No, the other 2 I got to comply, luckily.
Okay.
Floors and More. I'm
All
trying
right.
to
So there's a
remember.
recommendation for 20 days and another one for our next meeting. Any other comments?
I'm okay with the next meeting. I'm thinking, I don't know if we need to
Oh,
do
that's
the
Mr.
250,
Knowles,
but
isn't it?
I don't see a reason not to do 150 across the board.
Ariel, how about you? 20 days, next meeting,
Yeah, it is.
I like next meeting.
next meeting.
I'm okay with next meeting.
Okay.
What
And how about any add-on?
I'm open.
why
for
was
the
it
amount.
50?
Well, Ben's kind of recommended 150.
It's right in the middle of the road. They've had enough time. They've been given notices. I think the town needs something for the effort and then recoup some costs incurred.
Ariel?
Yeah. What if these people had stopped doing business like in the town? And then we're fining them and they're like they've moved on. They're a practitioner at someone else's office. And in one example, obviously there's
believe-
residences that. But
If I remember correctly, she uses a website to kind of look, and they've renewed it. How does it work, Emily?
Yeah,
They've renewed it
I think that they
somewhere else.
check. Yeah, I think that they check to see if they renewed it with the county.
With the county, yeah.
And then ones that she's not sure, she'll send me an email, hey, can you go check and see if there's a business here? So these ones, I think she has reason to believe still are. The only one you really wouldn't know is Floors and More, because that's at an actual residence. I don't know if that's fairly new, because I don't recall Mr. Knowles having Floors and More. But he still lives there.
yeah,
So that may be one.
yeah, that's
know,
one
they've
he
gotten
couldn't
letters,
get away with. That's
And
why.
I think the letter also says to you have to respond in writing if you're not operating.
Yeah.
So like
mhm.
that resident, for example, who's always home,
Gotcha. Okay.
would have been able to send a letter saying, hey, I don't have this business, or even at least called.
Right.
Normally any violation that I have sent that resident, his wife calls and says that we need to speak to only her. So I was surprised that she didn't respond to it. So
Yeah, and I have the
they're there.
notices here, and it says on
Oh,
them
perfect.
that that they can write us, if the business closed.
Okay.
I'd like to add another point of discussion. Since many of these, the majority of these businesses seem to be first time offenders, according to testimony, with the exception of Rock Point Academy. I would suggest to the board that we keep Rock Point Academy with the maximum penalty of $250, and all others that we kind of split the difference here, as was discussed previously, at $150.
Okay. Tim, any,
Yeah, that's okay.
okay with that?
Okay.
I'll go ahead and make the
Well,
motion if you'd like.
that's just, we're assuming Rock Point Academy is the only one, but there's, who knows?
right, I can't tell you for sure the other ones.
Yeah,
I'll
we don't
only tell
know.
you the one
I
I
was
know.
fine with the 250, so I'm fine with the 150
Okay.
also, so it's not a problem.
Okay,
It's just we got to state it as such when we were making them.
sure.
Right.
Tim, do you want to go ahead, or would you like me to make the motion?
I can do it.
Okay.
I can bash through them, okay? Based on the testimony and evidence presented in case number 21-0078, I move that this board find the respondent in violation of section 54-20 of the Town Code of Ordinances and impose an additional penalty in the amount of $150. The respondent will be required to pay a total of $150 plus 8820 plus 2205, which includes the past due business tax, the delinquency penalty, and the additional penalty. If the respondent is not in compliance by the next code enforcement meeting, which is
April
let's see,
28th.
April 28th.
April 28th, 2021, a lien will be recorded in the public records of Palm Beach County.
Second.
Is there any further discussion? All in favor of the motion signify by saying aye.
Aye.
Anyone opposed? Motion carries. Okay.
Okay, so let's go to the next one. Glores and more, okay? In case, based on the testimony and evidence presented in case number 21-0079, I move that this board find the respondent in violation of section 5420 of the Town Code of Ordinances and impose an additional penalty in the amount of $150. The respondents will be required to pay a total of $150 plus $66.15 plus $15.54, which includes the past due business tax, the delinquency penalty, and the additional penalty. If the respondent is not in compliance by April 28, 2021, a lien will be recorded in the public records of Palm Beach County.
Was that 1554 or 1654?
That is 1654.
Okay. Is there a second?
Second.
Is there any further discussion?
The only point that I would make, if we make the due date the 27th of April versus the 28th, I don't know if that makes a real big difference, but at least we have some concrete opportunity for them to be in compliance before the meeting.
You can give them the extra day, because in all reality, if they end up coming in
Okay,
that morning,
fair enough.
Emily will know.
Any further discussion? All those in favor of the motion signify by saying aye.
Aye.
Anyone opposed? Motion carries. Next item is
Based on the testimony and evidence in case number 21-0082, I move that this board find the respondent in violation of section 5420 of the Town Code of Ordinances and impose an additional penalty in the amount of $150. The respondent will be required to pay a total of $150 plus $66.15 plus $866, which includes the past due business tax, the delinquency penalty, and the additional penalty. If the respondent is not in compliance by April 28, 2021, a lien will be recorded in the public records of Palm Beach County.
Is there a second?
Second.
Is there any further discussion? All those in favor signify by saying aye.
Aye.
Anyone opposed? Motion carries. 0084.
Okay, based on the testimony and evidence presented in case number 21-0084, I move that this board find the respondent in violation of section 5420 of the Town Code of Ordinances and impose an additional penalty in the amount of $150. The respondent will be required to pay a total of $150 plus $66.15 plus $16.54, which includes the past due business tax, the delinquency penalty, and the additional penalty. If the respondent is not in compliance by April 28th, 2021, a lien will be recorded in the public records of Palm Beach County.
Is there a second?
Second.
Hello.
Second the motion. Second.
Any further discussion? All those in favor of the motion signify by saying aye.
Aye.
Anyone opposed? Motion carries.
Okay, next.
0085.
Okay, based on the testimony and evidence presented in case number 21-0085, I move that this board and find the respondents in violation of 5420 of the Town Code of Ordinances and impose an additional penalty in the amount of $150. The respondents will be required to pay a total of $150 plus $88.20 plus $22.05, which includes the past due business tax, the delinquency penalty, and the additional penalty. If the respondent is not in compliance by April 28th, 2021, a lien will be recorded in the public records of Palm Beach County.
Is there a second?
Second.
Any further discussion? All those in favor of the motion signify by saying aye.
Aye.
Anyone opposed? Motion carries. 0086.
Based on the testimony and evidence presented in case number 21-0086, I move that this board find the respondents in violation of section 5420 of the Town Code of Ordinances and impose an additional penalty in the amount of $150. The respondents will be required to pay a total of $150 plus $88.20 plus $22.05, which includes the past due business tax, the delinquency penalty, and the additional penalty. If the respondent is not in compliance by April 28, 2021, a lien will be recorded in the public records of Palm Beach County.
Second.
Any further discussion? All those in favor of the motion signify by saying aye.
Aye.
Is there anyone opposed? Motion carries. 0087.
Based on the testimony and evidence presented in case number 21-0087, I move that this board find the respondents in violation of section 5420 of the Town Code of Ordinances and impose an additional penalty in the amount of $150. The respondents will be required to pay a total of $150 plus $66.15 plus 79 cents. Which includes the past due business tax, the delinquency penalty, and the additional penalty. If the respondent is not in compliance by April 28th, 2021, a lien will be reported in the public records of Palm Beach County. I've got a question. 79 cents? That seems kind of
Yeah, it
unusual.
looks a little low to me too. I'm not sure this is the correct amount.
I don't think that's the correct amount. Just doesn't look right to me.
Well, you could just amend or change your motion to just say that the person must pay.
The late fee.
Yeah,
Well, that, I already said that.
penalty.
I already said that.
Pay the
Okay.
late fee and just
The
not.
late fee is $8.66, isn't it?
Should be.
Yeah, that's what I was noticing, the pattern.
No, but if
The
you
other-
look at some of the others,
No, this, it's all over the
6615s, they have
board.
different
Yeah.
amounts, so you can't really go off of that.
So in this case, you
Maybe
just
have it
want to
correct.
say the recorded late fee?
Yeah, that's fine. That's fine for me. Yeah,
Okay.
I move that it not be 79 cents, but it would be the late penalty as found. Okay?
Second the motion.
Any further discussion? All those in favor of the motion signify by saying aye.
Aye.
Is there anyone
Aye.
opposed? Motion carries.
So Rock Point, we're going to do 250, correct?
Correct.
That's what
Okay.
we said.
Okay. Based on testimony and evidence presented in case number 21-0089, I move that this board find the respondents in violation of section 5420 of the Town Code of Ordinances and impose an additional penalty in the amount of $250. The respondent will be required to pay a total of $250 plus $88.20 plus $22.05, which includes the past due business tax, the delinquency penalty, and the additional penalty. If the respondent is not in compliance by April 28, 2021, a lien will be recorded in the public records of Palm Beach County.
Second.
Further discussion? All those in favor of the motion signify by saying aye.
Aye.
Is there anyone opposed? Motion carries. 0090.
Based on the testimony and evidence presented in case number 21-0090, I move that this board find the respondents in violation of section 5420 of the Town Code of Ordinances and impose an additional penalty in the amount of $150. The respondents will be required to pay a total of $150 plus
66.
$66.15 plus $866, which includes the past due business tax, the delinquency penalty, and the additional penalty. If the respondent is not in compliance by April 28, 2021, a lien will be recorded in the public records of Palm Beach County.
Second.
Further discussion? All those in favor of the motion signify by saying aye.
Aye.
Anyone opposed? Motion carries. 0091.
Based on the testimony and evidence presented in case number 21-0091, I move that this board find the respondents in violation of section 5420 of the Town Code of Ordinances and impose an additional penalty in the amount of $150. The respondents will be required to pay a total of $150 plus $88.20 plus $22.05, which includes the past due business tax, the delinquency penalty, and the additional penalty. If the respondent is not in compliance by April 28, 2021, a lien will be recorded in the public records of Palm Beach County.
Second.
Further discussion? All those in favor of the motion say aye.
Aye.
Is there anyone opposed? Motion carries. Emily, thanks for these.
You're welcome.
If I could just address one issue that's unclear. It was pointed out that on some of these, the business tax amount is 6615. 25% of this, of the 6615 is 1654, but some of them indicate 866. I think it would be appropriate to clarify that if that 866 is an incorrect amount, that late penalty be the 25%, which is 1654.
I'll make a motion.
How do we do that, Trevor?
I think we can do that across the board to adjust it, just as one motion.
Okay.
That the intent was that if in fact the dollar amount stated is incorrect, it's 25% of the business tax.
So I'd like to make a motion that on case numbers 21-0078 up and including 21 dash, can you scroll up just a little bit, Emily? 0099, the previously were the aforementioned motions that were passed.
999 is in compliance. That's Thomas Cheatham.
Okay, up to include, so 21-0078. Let me just do them individually
It's okay.
so that
MedLife was the other one.
I'm gonna, so I'll list each one individually. I'm not gonna make a motion for each single one, but I move this board to amend the late penalty fee that was imposed to reflect the maximum statutory allowed late penalty fee according to Florida statutes for motions that were made, including cases 21-0078, 21-0079, 21-0082, 21-0084, 21-0085. Emily, can we scroll up just a little bit? 21-0086, 21-0087, 21-0089, 21-0090, 21-0091. That's my motion.
Okay, is there a second?
Second.
Any discussion on Mr. Sanchez's motion? All those in favor of the motion say aye.
Aye.
Is there anyone opposed? Motion carries. Thank you, everybody. The next item of business is
Roof industry.
board discussion. Emily?
No, it's Patricia. He wrote
Boat and
case
driveway.
number 21-0070.
All right. Dana?
Yes.
0070, is that? Boat in the driveway?
No. This is the
Which one is this?
boat in the driveway was in compliance. This is the one with the roof in disrepair, 7741 Westlake. It's number 21-0070. Yeah. On February 11th of 2021, I issued the property located at 7741 Westlake Drive a violation for the roof in disrepair. And as you can see, it has a tarp on it, on a good portion of it. Section 34-20 and 34-19, subsection 9C. I did speak with Mrs. Rott. She contacted me and said that there was an ongoing issue with her insurance company, so I recommended it come before the code board like we do in other cases as well. She did become a little upset with me, told me that she was elderly and would not be able to come to the meeting. I told her we would be more than happy to accommodate her. I could put her on speakerphone, whatever worked for her, we would be okay with it. And she did end up telling me that her daughter was coming to represent her. But in all that conversation on February 18th, based on speaking with her 2021 at 10:15 a.m., the hearing notice for today was issued for that same case. And she also on that same day provided a letter addressed to Mrs. Mannington. I believe that is her daughter who's helping her. And it just says, this email confirms that we are actively litigating your mother's Hurricane Irma case against her insurance company, Universal, which includes the roof replacement for the property located at 7741 Westlake. And at this time, no offers have been made. Hurricane Irma was quite.
Where is this on Westlake?
Yeah. 7741. It's actually right across the street from Mrs. Terhun's house.
Oh, so
Kinda
it's
diagonal
that far
from it.
up, okay.
Yes.
Do we need to bring this letter into a,
I would,
I put it with the violation.
I'd recommend that you have a motion to receive and file it as part of the record.
Do you guys want to look at it?
no, I don't need it, but you just read it.
No, you read it into the
No.
record. And I'd like to make such a motion and reiterate the same motion.
Is there a second?
Second that.
Any discussion? All those in favor signify by saying aye.
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 Anyone opposed? Motion carries. Okay, so do you have any idea how long this tarp has been on the house, Dana?
For a while, I wouldn't be able to say exactly how
You don't want
long.
to speculate, but it's been more than a couple months?
Oh, yeah.
There are a number of open roof claims to insurance companies still open in Lake Clark Shores
And they'll all be
related
coming
to the
here.
last hurricane.
That's a long time.
It's just the nature of the process. Nature of the process.
I think that one of the concerns is that once it becomes a litigated issue, there really is no motivation for the homeowner to be in compliance. And I want to speak as broadly as I can and not just in this specific case. But you know, we are in an area that is prone to hurricanes. Everybody moves into the area knowing that full and well. And I think that we've all, I'm going to go out on a limb and say we've all kind of lived through a hurricane, one or two at least. And it is devastating what can happen. And certainly I feel for any property owner that does have a leak. But our function as the code board is to make sure that that we have our residents complying with what is promulgated by town council. With that being said, we don't have any idea in terms of when the leak happened. They had mentioned that it was from Hurricane Irma. And does anybody have a date or a year of when Hurricane Irma was?
The 27.
That was,
More
yeah,
than
I
a
think
year.
around 2017.
Okay.
And I kind of wish Trent was here because this is a specialty of his when it comes to litigating insurance claims. And I know there is a limit on the amount of years it can go, which I think it's,
36 months.
yeah.
It's 36 months.
So unless this tarp has been on since 2017, which I don't think it has, the only way to spur action of any kind would be to find them in violation. And that either moves their case along and has them put pressure on their attorney
Sure.
or insurance company or what have you. But unfortunately, I think that they're fighting an uphill battle and are not going to get this claim paid.
Well, and you make an interesting point, and I think that it's important that we advise the residents that if we do find somebody in violation, it is to hopefully get the insurance company to realize that there is a real need. And each contract is different, but contract law is 5 years. So you have a contract with the insurance company, you have 5 years to make a claim. Whether it's going to be paid for or not, but it is a 5-year window.
And Universal is a pretty big company too.
Right. And
So, something else to think about is a lot of these roofs here are very old. So you never know if the case could be their life, the life expectancy is that's past due, and maybe that's why they're not, getting covered. You never know.
yeah. And I mean,
This roof is older than 15 years.
the real concept that I think the law recognizes is no matter, regardless of whether or not litigation is underway, every property owner has a duty to mitigate their damages. And I think that having a tarp on here for an extended period of time, while it mitigates your damages in the short run, I think that having a tarp on there in the long run could actually cause more harm to that roof, causing more expensive repairs. Who ends up paying for it at the end of the day, or if that property owner gets reimbursed, it's certainly something that we have to make sure it does get repaired and that they are in compliance. So,
Well, our charge is
That's
to
what you've done in the
determine
other
whether
houses.
a property is in compliance or not.
All right. So, go to
Is there a motion?
You look ready to go, Ariel. You want to do it?
Well, I disagree with everything that's just been said. So, I don't know what to tell you. I've worked in the insurance restoration industry for a better part of the last 20 years. And this is the process, okay? And we did attempt to do this before with a roof issue last year, and it resolved nothing, okay?
She actually, she took care of her roof and she cleaned it. That was the one that Trent
Now,
Swift,
this is a repair issue, okay, that
but hers had a tarp on it.
Well,
Also, Tracy
you know,
Cook's case.
I don't know what to say, okay? It's an insurance claim, it's in litigation, okay? I don't know what to tell you. I was just with
Pushed the
a
road,
public
took care of it.
adjuster yesterday, and we were looking at a roof that is right on Westlake also that is in litigation, okay? And it's a process, and these insurance companies have a difficult time paying for roofs in Florida because of the cost of replacement of roofs. And they're gonna stick up and stick up and stick up and try and prevent from paying it as much as possible. It's that simple. And if you've got a tarp on it, you're mitigating the damages. That's what you're doing, okay? And it's between the insurance and the insured, or it's between the insurance and the insured and the lawyers, or the insurance and insured, or the public adjuster. So I don't know what to say, to hold that person, at fault for something that is not their fault. Okay, I don't find that to be a valid thing to do, honestly. They put a tarp up on there. They're in litigation. That's the way it works. That's the process.
Tim, do you want to make a motion?
Well, obviously somebody else was planning to make a motion.
But you can make one if you
Well,
want.
no, I'm not going to do it because my motion is going to be voted down anyway. I know where the majority is going with this, okay? So I don't see any need to, okay, I'm just stating my feeling on that, okay?
All right. Someone like to make a motion?
I actually want to know from Dana if you could remind me in your testimony, did you mention there was, I think you said that they were communicating or trying to keep you up to date or anything like that?
No, she just gave the
But
letter.
they didn't show, I
She
guess
said
they're not able to
her
show up?
daughter was coming because I offered the speakerphone.
Uh-huh.
You know, we're a town that would always accommodate.
And
Not a
is there
problem. And
anybody
she said
online, like logged in online to see, like to attend?
she was supposed to call me if she needed speakerphone, but then she had
Oh,
said,
okay.
"Oh, my daughter's gonna come." The letter is very basic. I would say.
Does
it
the
doesn't
letter
really-
look
it doesn't
like
really
it's
tell
from an
you
attorney?
much. Just sounds like an attorney saying, "Oh yeah, we're taking care of it."
And who's the letter from again? Yeah, thank you.
Alexis Altman.
Is it the organization? What's the
It says K.
Canner and
Kate
Pintaluga?
Canner and Patel.
Canner and
Yeah.
Pintaluga, they're plaintiffs,
But that's it. I mean,
litigation.
So it's a firm.
you would think
So it's all-
that they would
okay.
give you like, it's coming before a hearing. They would give you, hey, on this date we spoke with them. This is where we are. It just sounds like, hey, we have your case. That's it.
Probably got a docket, but no
No offers have
date,
been
right?
made.
So, I mean, I'm okay with continue, like, are they in violation, black or white? Yes, but can we work with them? I think so. Could we
You mean
continue
postpone it?
something? Find them in violation, but postpone until, or,
You can find them in violation and you
Always
can
take the
say
fines off.
how much, and you can say if they don't come into compliance by a certain date, then the fine may be imposed.
I mean, regardless of whether they're in litigation or not, I think that may be a story for another day. And I'm just trying to make sure that we create a precedent and create a rule that is fair to everyone. So the issue is the tarp on the roof, regardless of whether they're litigation or not. And I'm thinking of a person that is not involved in litigation and just has a tarp. I think that it would be unfair to give deference to somebody that's involved in the litigation process because they have a tarp versus somebody that is not and just has a tarp
You can't afford to fix it.
and can't afford to fix it. It's the
same
same kind of principle here. And I acknowledge and I appreciate that insurance companies are the worst to work with sometimes. I go against them every single day. But the underlying issue, what we are charged with, is to abide and uphold this town's direction and rules and laws. So I'm going to go ahead and it saddens me to do this. It doesn't bring me any joy to do this, but we don't have to impose a fine, right? In the future. But I do think that in making my motion, it is a motion that is the most fair to all of the residents. And so with that being said, based on testimony and evidence presented in case number 21-0070, I move that this board find the respondents in violation of section 34-20, 34-19, sub 9, sub C, roof and disrepair, and has a tarp on it of the town code of ordinances. I move that the respondent be ordered to correct the violation on or before April 28th. And if respondents fail to comply with this order, a fine in the amount of $50 per day may be imposed.
I'll second that.
Further discussion?
I think realistically, I mean, they're not gonna come into compliance in 30 days because they got pull permits and all, and then they'll first off shop it around, pull permits. I think realistically, they're gonna need more time.
But that's why
So,
the fine may be imposed, which keeps it in our court. And all we're really looking for is an update of some kind, whether it's further
Okay.
communication from them, advancement of the hearing, something in form of that. It's just to keep
Yeah,
everybody
thanks for
on the same
clarification.
page.
Yeah, I think that
all right,
finding the violation is going to encourage more communication with the board so that we can hear from the resident and that we can get them involved in the process and see if we can collectively find a way forward.
I'm okay with that. Oh,
Ready to vote?
yeah. Thank you.
All those in favor of the motion signify by saying aye.
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 Anyone opposed?
I'll be opposed.
One opposed. Motion carries. Are there any more cases?
No.
No?
No.
Okay. Is there any board discussion about it? Anything you need to talk about or want to talk about?
I just wanted to make a quick comment for Mr. Hune. We don't really know exactly what's going on with her, but I wish her well. I wish her family well. And yeah.
Okay. Is there a motion to adjourn?
I think it's, a town like Lake Lake Shore should have people coming together and helping each other out and something like that. So let's see if it's not too late. Maybe I could do something with others involved.
Definitely not too late.
Because, I mean, you never know how big a lift it is or whatever, but it just feels like we should be looking to find ways to help each other as
I
a
agree.
community. And those are my 2 cents.
Thank you. Is there a motion to adjourn?
So moved.
Is there a second?
Second?
All in favor, signify by saying aye.
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 Aye. Meeting adjourned. Thank you, everyone.
Thank you, Paul.
Just so you know, Ariel, the last time that I had